Nine lawyers, just 9 unelected people in robes. What happens when they decide the future of a nation, overriding laws passed by hundreds of elected representatives, or even, overturning centuries of legal tradition?
That is the incredibly high-stakes question right at the heart of Thurman Leonard Smith's, definitive work, Supreme Damage, Rescuing Representative Government from Judicial Overreach. And Smith's central argument, it isn't really about whether we like certain judicial outcomes, it's about something deeper, the fundamental collapse of process. He argues the federal judiciary has stopped just interpreting law and has fully morphed into a policy-making super-legislature. It's steadily moving public policy away from constitutional representative self-government.
And that transformation, that shift in, who actually holds the power to decide society's direction, that's precisely what we're diving into today. Our mission really is to analyze Smith's source material, looking at case after challenging case, to understand how this judicial overreach has fundamentally reshaped American governance.
Yeah, and maybe most critically, what this actually means for the survival of Republican self-rule. To really appreciate the extent of the damage Smith describes, we really have to start with the constitutional baseline. We have to remember how the framers originally saw this third branch.
Because it wasn't supposed to be the driver of policy, was it?
Not at all.
It seems almost inevitable today, this perception that the Supreme Court is the final supreme arbiter on, everything. But that idea would have absolutely stunned the founding generation.
Absolutely stunned them. Alexander Hamilton, in Federalist number 78, famously assured Americans the judiciary would be the least dangerous branch.
Right.
He explained that unlike the executive, it had neither the power of the sword nor, unlike the legislature, the power of the purse. It relies only on judgment. It was meant to be passive, constrained, really focused solely on interpreting pre-existing law.
So the ultimate referee, basically, making sure the game follows the rules written down in the Constitution. And we see this limited view reinforced back at the Constitutional Convention in 1787. James Madison's notes, they clearly document that a proposal, I think it was called the Council of Revision.
That's right.
Which would have allowed both the executive and the Supreme Court to review and, essentially veto acts of Congress. That was rejected.
Flatly rejected. The framers did not want judges involved in the actual making of law.
That rejection feels really important as context here.
It's vital context. Now, look, we have to acknowledge that Marbury v. Madison in 1803 established the critical power of judicial review, the ability to interpret laws against the Constitution and strike down those that are unconstitutional. That was intended as a checking mechanism, right? A tool for enforcement.
So the power to interpret the Constitution, to check the other branches, that's one thing. But Smith argues that later courts didn't just use this power, they weaponized it.
That's his argument, yes. They morphed judicial review into something far more dangerous, something he terms judicial supremacy.
Judicial supremacy. Okay, what's the difference there?
Well, judicial supremacy is this arguably radical notion that the Supreme Court's pronouncements aren't just an interpretation based on text and history, but the final, definitive, unchallengeable word.
Binding on everyone.
Binding on all branches, yes. Even if that interpretation seems to disregard the clear original meaning of the document itself, it effectively means the Constitution means whatever the court says it means today.
Regardless of history or text.
Regardless of history, text, or how many states or legislative bodies might disagree.
Wow. That seems like a direct conflict with the whole idea of representative self-rule, doesn't it? If 9 unelected individuals can dictate policy like that, why even bother electing representatives?
That's precisely the tension Smith highlights.
Okay, let's unpack the mechanics of this overreach then. Starting with Smith's critique of judicial activism. He makes it really clear this isn't just, disagreeing with the outcome of a case.
Right, it's not about, I don't like that result.
It's about a deviation in interpretive methods, like cheating on the basic rules of how you're supposed to interpret the law.
Exactly. He identifies a whole slew of methods: abusing precedent, contorting the actual text, importing foreign law, sometimes exhibiting what he calls judicial dishonesty. But he really singles out 3 as the most pervasive and damaging to the fabric of self-government: living constitutionalism, playing legislator, and nullifying rights.
And if we're looking for the engine, the main driver behind almost all of these policy decisions Smith points to, it seems to be living constitutionalism. That's the interpretive method that basically gives judges permission to dissolve the textual constraints entirely.
That is absolutely the linchpin of Smith's argument. And the definition is key here. Living constitutionalism is the belief that judges can construe the Constitution, which is, fundamentally a fixed written document. It knew social needs, political demands, current conditions that the original drafters couldn't possibly have foreseen.
And they do this without using the amendment process.
Crucially, yes, without needing to follow the difficult but constitutionally required amendment process outlined in Article V. They just reinterpret.
And the consequence of adopting that kind of fluid, ever-changing interpretation, well, Smith argues it's devastating to liberty.
It has to be, according to his view. If the meaning of the highest law in the land is malleable, if it can be set by 9 unelected, arguably politically attuned individuals, then governmental authority has been irrevocably transferred.
Where does it go?
It moves away from the people and their elected legislatures, who you can hold accountable at the ballot box, to a small, unaccountable legal elite.
It's interesting that you mentioned this kind of policymaking often doesn't start with a big explosion.
No, it can be quite subtle. Sometimes it's introduced through non-binding commentary, what lawyers call obiter dicta.
The saying, by the way.
Exactly. Language the judge includes that isn't strictly essential to the ruling itself, but it offers hints about their current thinking, or perhaps where they want the law to go.
Like planting a seed, a legal time bomb set in the corner, just waiting for the right future case to make it explode into actual law. But how does that work? How does non-binding commentary actually become binding?
Well, it acts as a kind of signaling mechanism for future litigants and, importantly, for other judges. One great example Smith uses is United States v. Butler back in 1936. The actual ruling in Butler struck down an element of the Agricultural Adjustment Act. But within the opinion, there was extensive commentary dicta that essentially paved the way for a really expansive Hamiltonian interpretation of the federal power to spend for the general welfare.
So even though they struck down that specific tax scheme?
Exactly. They struck down the scheme, but they left this massive door wide open for Congress to spend on virtually anything later on, using this broad general welfare idea.
That's a really crucial insight. The damage isn't always in the holding itself. Sometimes it's in the hint, the dicta. And I guess the most notorious example of this kind of subtle shift has got to be footnote 4 in United States v. Caroline Products. So that was 1938.
Yes, absolutely infamous. The Caroline Products case itself, it dealt with economic regulations, specifically banning the shipment of something called filled milk in interstate commerce. Kind of obscure now, but footnote 4, tucked away in the opinion, launched this entirely new dual role for federal courts that, well, it persists right down to today.
A dual role? What do you mean?
Well, before the footnote, the court was still willing to review economic legislation with some actual rigor. But footnote 4 suggests they would start applying a heavily differential standard, what we now call the rational basis test, to economic legislation.
Okay, let's pause there. Can you clarify for our listener what's the practical difference? Rational basis versus, say, more rigorous review.
Oh, it's night and day. It's basically the difference between a rubber stamp and a forensic audit. Under rational basis review, the law is presumed constitutional from the get-go. The government simply needs to show that the regulation is rationally related to any legitimate state purpose, any plausible reason, even one they make up after the fact.
So, if the state can offer just some kind of plausible, even hypothetical reason for the law,
the court says, we defer to the legislature. It's a near impossible standard for someone challenging the law to beat. It almost always gets upheld.
But the footnote also suggested that for legislation touching non-economic issues, things like fundamental rights or laws aimed at what it called discrete and insular minorities, the courts would apply something much tougher: strict scrutiny.
Precisely. Strict scrutiny is the forensic audit. Here, the burden shifts entirely to the government. They have to prove that the law is necessary to achieve compelling state interest and that it's narrowly tailored.
And that's much harder for the government to prove.
It's a nearly impossible standard for the government to meet. It often leads to laws being struck down. It's sometimes called strict in theory, fatal in fact.
So footnote 4 essentially signaled this massive trade-off. The court basically decided, look, we're mostly done protecting economic liberty and property rights. We'll let the political branches handle that.
Yeah, defer heavily there.
But, they said, we will heavily police certain non-economic rights using strict scrutiny.
Exactly. And this completely redirected the entire flow of future litigation and federal court involvement. It shifted the focus away from protecting, say, the right to earn a living and towards social issues and fundamental rights as the court defined them.
Okay, so this new approach, deferential in some areas, really interventionist in others, it immediately led to a dramatic expansion of federal power. Let's talk about Congress's ability to spend. We're moving into Act 2 now, looking at those New Deal-era cases Smith covers in Chapter 2, Stewart and Machine Company v. Davis and Helvering v. Davis, both in 1937.
Right. These cases fundamentally redefine the general welfare clause of the Constitution, and we really have to appreciate the original debate here.
Between Madison and Hamilton.
Exactly. James Madison believed federal spending was restricted only to the powers explicitly listed, enumerated later in Article I, Section 8, things like establishing post offices, building a navy, concrete function.
The limited government view.
The limited view. Hamilton, on the other hand, argued the federal government could spend for almost any benefit to the country as long as it promoted the general welfare, a much broader view.
And Madison's view held sway for a long time.
Madison's restrictive view pretty much prevailed for nearly 150 years, but that 1937 shift, really enabled by the dicta we just talked about in Butler, fully adopted the Hamiltonian position.
So the floodgates opened?
Completely. The court allowed the federal government to spend money on things outside of those strictly enumerated operational activities. This move immediately greenlit modern welfare payments, entitlements, huge, highly political, discretionary spending programs.
And it also gave the federal government a powerful new tool, didn't it? A lever to control state policy. Basically, coercion through cash.
That's exactly what happened in Stewart Machine. The court upheld unemployment compensation provisions. These created a national taxing structure cleverly designed to induce states to adopt similar state-run unemployment laws.
How did they induce them?
Well, the structure was, if a state set up its own compliant unemployment system, businesses in that state got a huge credit against the federal tax. If the state didn't set up a system, its businesses paid the full federal tax anyway, but the state and its citizens got none of the benefit.
It wasn't really a choice.
The court argued it was inducement, not coercion, that states were technically free to say no, but practically speaking, the penalty for opting out was enormous. It was essentially the federal government using its taxing and spending power to compel state actions by tying these massive grants and aid to specific federal requirements.
The erosion of federalism here just seems staggering. Smith points out the numbers, right? The quantitative consequences.
Yeah, the numbers are stark. In 1930, there were about 15 federal grants and aid programs. By 2018, that number had exploded to over 1,200. And this grant regime, Smith argues, has two major constitutional costs. First, it stifles state innovation. It forces these one-size-fits-all mandates from Washington onto very diverse states. Remember the old national 55-mile-per-hour speed limit tied to highway funding?
Yeah, I remember that.
That's a classic example. Second, it fundamentally confuses citizens about where governmental responsibility truly lies, who's really in charge.
Right.
When the federal government pays for state programs, the states can become mere administrative arms of D.C. And that essential constitutional role of states as, laboratories of democracy gets severely diminished.
So if the spending power was expanded to cover almost any policy, the Commerce Clause was, at the same time, weaponized to regulate practically all economic activity. Let's turn to Chapter 5 and that infamous 1942 case, Wickard v. Filburn.
Ah, Wickard, yeah. Before the New Deal court really took hold, the Commerce Clause was primarily understood to give Congress power over trade between the states. The main goal was to eliminate protectionist state barriers, create a national free trade zone. It was about actual commerce, goods crossing state lines, traffic and trade. But Wickard stretched that power to a degree that, well, to many people, seems fundamentally absurd.
Tell us about the case. Who is Roscoe Filburn?
Roscoe Filburn was a small Ohio farmer. He was fined by the Department of Agriculture for growing more wheat than was permitted under the Agricultural Adjustment Act. And here's the absolute key detail. The excess wheat he grew was solely for consumption on his own farm.
It never went to market.
Never entered the stream of commerce. It fed his family, fed his livestock. It never left his property.
So that's the core question then. Can the federal government regulate what a man grows in his own garden, essentially, for his own family's use.
Exactly. Filburn argued this was clearly a local, purely interstate activity. It had nothing to do with interstate commerce. But the Supreme Court disagreed, and they established this revolutionary affecting interstate commerce reasoning.
Okay, what was that reasoning? How on earth did they justify regulating a man's dinner plate under the Commerce Clause?
Well, the court argued that because Filburn's homegrown wheat supplied a need that he might otherwise have met by buying wheat on the open market.
Might have.
Might have. It therefore affected the overall national market demand for wheat. Even if his individual impact was trivial, absolutely tiny, when you aggregated his actions with the potential actions of millions of other small farmers like him, it affected interstate commerce, and therefore Congress could regulate it.
Wait a second. If the mere potential lack of participation in a market is enough to trigger federal regulatory power under the Commerce Clause, then what isn't subject to federal regulation? That reasoning seems to effectively erase the whole concept of enumerated powers.
It pretty much does, according to Smith. He argues very powerfully that this ruling substantially deprecates, basically ignores, the concepts protected by the 9th and 10th Amendments, the ones that reserve powers not delegated to the federal government, to the states, or the people. If growing wheat for your own use can be regulated because it affects the national market in some theoretical way, then practically anything related to economic activity, or maybe even inactivity like not buying health insurance, could fall under this vast umbrella of federal authority.
So Wickard really laid the legal foundation for the entire modern administrative state that regulates so much of our lives today.
It's arguably the cornerstone, yeah.
Okay, so Act 2 showed how the court expanded federal power by really gutting the limits on spending and commerce. Act 3 now shows the flip side, the systematic erosion of individual liberty and property rights, starting, as Smith details, with the death of economic liberty.
Right. This really begins with the formal end of what's known as the Lochner era in 1937. The Lochner court had recognized certain economic rights, specifically the freedom of contract, as being protected by the 14th Amendment's Due Process Clause.
So the right to agree on terms of employment, wages, that sort of thing.
Exactly. It was considered a fundamental liberty. But the big shift came with West Coast Hotel v. Parrish in 1937. That case upheld a state minimum wage law for women, and Smith argues this case effectively abandoned the constitutional protection of economic liberty, choosing instead to defer to temporary political preferences about social welfare.
How did the court justify that shift?
The court stated that liberty is only safeguarded when it protects the community, health, and safety. This marked a really sharp increase in jurisprudential deference courts, just stepping back and letting the political branches do what they want, whenever the government claimed some kind of public safety or welfare interest, even when it restricted individual economic liberty.
And this deference was then sort of locked in place the following year.
It was codified, yes, in United States v. Caroline Products, the same case with footnote 4. That case established the rational basis test we discussed earlier for pretty much all economic regulation going forward. Rubber stamp approval became the norm for economic laws.
And the consequence of this judicial retreat from protecting economic liberty, Smith argues, is highly relevant today. It's not some dusty historical issue.
Not at all. Because courts rarely scrutinize economic legislation anymore, we see this flood of special interest laws. Laws often designed not really to protect the public, but to limit competition and protect incumbent businesses.
Like occupational licensing laws.
Exactly. Occupational licensing laws requiring hundreds, sometimes thousands of hours of expensive training for jobs that don't genuinely affect public safety. Smith mentions things like requiring licenses for flower arranging or hair braiding or even selling caskets. He contends that the fundamental right to earn an honest living, which he sees as an unenumerated right protected by the 9th Amendment, has been diminished almost to the point of being ignored. Because courts now just presume the state must have some rational reason for restricting your ability to work.
Okay, so economic liberty took a hit. Next, Smith details the judicial assault on property rights, specifically through reinterpreting the Fifth Amendment's Takings Clause.
The amendment clearly states that private property cannot be taken for public use without just compensation. Pretty straightforward, you'd think.
And what did public use traditionally mean?
Traditionally, it meant exactly what it sounds like. Something the public would actually use. A road, a fort, a post office, maybe a reservoir, government ownership, or public access.
But that understanding started to unravel.
It started to unravel in a case called Berman v. Parker in 1954. In Berman, the court expanded public use to encompass a much broader concept: public purpose.
Purpose, not use.
Purpose, not use. Specifically, Berman upheld the taking of perfectly fine, non-blighted property within a generally blighted area simply because it was part of an integrated plan for urban renewal. The court explicitly deferred to the legislature's determination of what served the public purpose.
So the court essentially swapped out the word use for purpose, giving massive deference to whatever the legislature decided was good for the public. But the real disaster, the one that caused a huge public outcry, came much later.
That would be Kelo v. City of New London in 2005. For Smith, this is the ultimate example of rule by jurist judges substituting their own policy preferences, or rather deferring to the legislature's policy preferences instead of upholding the constitutional text.
What happened in Kelo?
The city of New London, Connecticut, wanted to take perfectly well-maintained homes from private owners, including the lead plaintiff, Suzette Kelo. Not for a road, not for a school, not for anything the public would directly use.
But for what then?
Solely for the projected economic benefit the city hoped to get through increased tax revenue from a planned private development, specifically a facility for the pharmaceutical company Pfizer.
So, taking property from one private citizen, perfectly fine property, and handing it over to another private company, just based on the hope of getting more taxes, how did the court majority possibly justify that as public use?
They doubled down on the Berman logic. They argued that the anticipated economic revitalization served a public purpose, and that was good enough under the Fifth Amendment.
Wow.
Smith details Justice Thomas's blistering dissent in Kelo. Thomas argued that this ruling rendered the public use clause a virtual nullity, completely meaningless.
A dead letter.
Pretty much. And Thomas famously noted that this practice often facilitates a kind of reverse Robin Hood effect-taking from the poor, or at least less politically connected homeowners, and giving to the rich, powerful developers.
And the punchline to the Kelo story is pretty telling, isn't it? What actually happened to the land where Suzette Kelo's house stood?
That's the tragic irony. The judicial policy preference, the deference to the city's economic plan, failed spectacularly. After years of litigation and expense, the development deal with Pfizer completely collapsed. Today, the land where Suzette Kelo's little pink house once stood is a vacant lot, weeds, maybe some feral cats. It's just this barren symbol of judicial overreach, allowing property seizure for economic development that never even happened.
Okay, finally in this section, Act 3, Smith argues the judiciary even redefined citizenship itself, starting way back with United States v. Wong Kim Ark in 1898.
Right. This case involved interpreting a key phrase in the 14th Amendment, the Citizenship Clause. It says persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens.
Subject to the jurisdiction thereof. What was that phrase originally meant to cover?
Well, Smith argues the historical intent of the amendment, adopted right after the Civil War, was primarily to guarantee citizenship to the newly freed slaves, overturning the horrible Dred Scott decision.
Okay.
And that phrase, subject to the jurisdiction, was intended to exclude certain groups. Children born to foreign diplomats, members of invading armies, and importantly, members of Native American tribes who still owed allegiance to their own tribal sovereign, not fully to the U.S. government.
But the Wong Kim Ark Court interpreted that phrase much more broadly.
Very broadly. It basically applied the principle of jus soli citizenship based purely on being born on the soil to virtually all children born physically within U.S. borders, regardless of whether their parents owed allegiance to another country or were just temporarily present.
So birthright citizenship as we know it today.
Pretty much. Smith views this as a significant judicial departure from the original understanding, adopting a standard that bypassed the allegiance component and created this avenue for mass automatic citizenship based purely on location of birth.
And he argues this foundation was then compounded decades later by Plyler v. Doe in 1982. You mentioned dicta before. This case is another example.
A huge example of dangerous dicta, according to Smith. Plyler v. Doe struck down a Texas law that had withheld state funds for the education of children who were undocumented immigrants, children of unlawful entrance.
How did the court justify that?
Justice Brennan's majority opinion relied heavily on, believe it or not, a single footnote citing an obscure legal treatise. This footnote essentially equated lawful resident aliens and unlawful resident aliens for the purposes of the 14th Amendment's jurisdiction when it came to granting state benefits.
So using a footnote to say that illegal status doesn't matter for getting state benefits like schooling.
Basically, yes. It mandated free public education for the children of illegal entrants, paid for by state taxpayers. Smith highlights that this decision, particularly the reasoning in that footnote, dramatically accelerated the growth of what's often called the anchor baby phenomenon.
Explain that connection.
Well, by ensuring that any child born in the U.S., regardless of the parent's legal status, instantly gained not only citizenship, Wong Kim Ark, but also access to significant state benefits like education, Plyler, it created a powerful incentive structure. Smith argues it facilitated chain migration and resulted in substantial ongoing public costs being subsidized by taxpayers. It arguably created a system that rewards bypassing legal immigration channels.
All right, moving into our final act, Act 4. We've seen the expansion of government power, the erosion of economic and property rights. Now we shift to the judiciary's deep dive into legislating social and moral policy, starting with what Smith calls invented rights.
Yeah, and this narrative really requires tracking the rather convoluted birth of the so-called right to privacy. It didn't just appear fully formed in the Constitution.
No, it definitely didn't.
It started, famously, with Griswold v. Connecticut in 1965. That's the case where the court struck down an old state ban on the sale and use of contraceptives. But the question was, where did they find a right to use contraceptives in the Constitution? It certainly wasn't explicitly listed.
And the answer was kind of creative, right?
Famously creative, yes. Justice Douglas's majority opinion conjured it up from penumbras formed by emanations from other specific guarantees in the Bill of Rights.
Penumbras and emanations. Sounds pretty mystical.
It sounds like making it up, according to critics like Smith. The argument was that the combination of rights like association, speech, security in one's home suggested a broader, unwritten zone of privacy. It was, in Smith's view, the pure judicial invention of a right.
And that invented right then became the crucial foundation for Roe v. Wade just 8 years later in 1973.
Exactly. The Roe court rooted the right to abortion in the vague liberty language of the 14th Amendment's Due Process Clause, leaning heavily on that Griswold privacy concept.
And Smith is emphatic that this was done with complete disregard for the actual history surrounding the 14th Amendment.
The historical context is pretty undeniable, isn't it? When the 14th Amendment was adopted in 1868, abortion was actually criminalized in the vast majority of states. There is zero historical evidence suggesting the drafters or the ratifiers intended to protect a right to abortion within that amendment.
None at all.
None whatsoever. And for Smith, the most egregious aspect of Roe wasn't just finding the right, it was the result. It was Justice Blackmun's detailed trimester framework.
Right, the framework dictating when states could regulate abortion based on pregnancy stages.
Exactly. That framework, setting out specific medical and time-based rules, was a nakedly legislative act. It wasn't judges discovering existing law. It was judges dictating complex medical and public health policy directly from the bench.
Overriding the laws of all 50 states.
Overriding the diverse laws passed by elected representatives in all 50 states on an incredibly complex and deeply moral issue.
Justice White, in his dissent back then, called it an improvident and extravagant exercise of the power of judicial review.
And Smith would certainly agree. He argues it displaced the democratic process entirely, leaving citizens with basically no ability to influence policy on one of the most contentious issues imaginable through their elected bodies.
And this pattern of judicial legislation, Smith argues, continued right into the heart of family law. He points to Lawrence v. Texas in 2003, and then Obergefell v. Hodges in 2015.
Yes. Lawrence struck down state laws prohibiting sodomy, again relying on an expansive, non-textual interpretation of privacy and liberty under the Due Process Clause. For Smith, this was a direct assault on the principle of federalism, which had traditionally allowed state majorities to legislate based on widely held views of public morality.
And Justice Scalia's dissent in Lawrence is often remembered as being particularly prophetic, isn't it?
It really was. He warned very clearly that if the court ruled that moral disapprobation, meaning the community's collective moral judgment, was no longer a legitimate state interest for prohibiting certain sexual conduct,
then the same logic could apply elsewhere.
Then that same rationale would necessarily invalidate any law based primarily on a moral judgment, which, he predicted, would lead directly and inevitably to the constitutionalization of same-sex marriage.
And just 12 years later.
12 years later, Obergefell delivered exactly on that prophecy. Justice Kennedy's majority opinion essentially asserted that millennia of human social practice across virtually all cultures and the established state powers over domestic relations had somehow just had it wrong.
And that the Constitution, which says nothing about marriage, actually mandated a nationwide redefinition of it.
Exactly. Smith sees Obergefell as perhaps the ultimate proof of judicial supremacy in action. When the court issues these kinds of sweeping diktats on the fundamental social order, he also points to an earlier Massachusetts state court decision forcing same-sex marriage there. It proves, in his view, that citizens are no longer truly in charge of their own governments.
So rule of law, grounded in text and history, gets replaced by
rule by jurist, grounded in the evolving social preferences of 9 lawyers.
Okay, finally, we have to address how judicial deference, the court stepping back, also contributed to the problem, specifically by enabling the massive expansion of the administrative state.
Right, the so-called fourth branch of government. This vast network of federal agencies, EPA, FCC, SEC, you name it, that often function as rulemaker, enforcer, and judge, all rolled into one, which, seems to violate the basic separation of powers the framers intended.
And Smith argues the judiciary bears responsibility for enabling this.
He does, through 2 landmark decisions granting broad deference to these agencies. First, Chevron v. Natural Resources Defense Council in 1984. This established what's famously known as Chevron deference.
Explain Chevron deference.
In simple terms, it means courts must defer to an agency's interpretation of an ambiguous statute that Congress told it to administer, provided that the agency's interpretation is deemed reasonable.
So if Congress passes a law that's kind of fuzzy or unclear,
the unelected agency gets to decide what that law actually means in practice, and the courts just have to agree, as long as the agency's interpretation isn't totally outlandish or irrational.
That sounds like handing legislative power directly to the bureaucracy.
That's precisely the critique. But it didn't stop there. That massive delegation of interpretive, almost legislative power was extended even further by Auer v. Robbins in 1997. Auer deference requires courts to defer to an agency's interpretation of its own ambiguous regulations.
Wait, so the agency writes the rule, which might be unclear, and then the agency gets to tell the court what its own unclear rule means, and the court has to defer to too?
Pretty much, yes. Unless the interpretation is plainly erroneous or inconsistent with the regulation, it's deference layered on deference.
That seems deeply problematic for accountability.
It is. Smith argues that judges are fundamentally at fault here for basically accepting the government's argument for deference in these cases. Because by granting this broad, consolidated power to unelected administrators, the judiciary fundamentally weakened the checks and balances that were designed to protect liberty. When a single agency can effectively legislate, enforce, and then interpret its own rules with minimal judicial oversight, the result is accountability zero. The citizen is left with no clear avenue for democratic redress against bureaucratic power.
Wow. Okay, so Smith's deep dive through all these cases paints a really compelling, though frankly, a very concerning picture.
It is concerning from his perspective.
The overarching theme seems to be that when courts create rights untethered from the actual text, whether through penumbras or sociological preferences, or even non-binding dicta, or when they nullify existing laws through these kinds of doctrinal inventions, citizens lose the fundamental capacity for self-government.
That's the core argument. Law ceases to be predictable. Ordered liberty gets replaced by discretionary decree. Smith argues quite persuasively that ordered liberty requires laws that actually reflect the consent of the governed, not just the policy preferences of 9 jurists, however wise they may be.
So laws should be discovered based on text and history, not just made up.
Exactly. Discovered within the framework of the Constitution and tradition, as in classical natural law and common law thinking, not decreed from on high. When judges start decreeing new social arrangements, they end up redirecting family law, immigration policy, economic policy, education policy, all without democratic consent.
Smith's central thesis seems crystal clear then. True liberty depends not just on achieving subjectively good outcomes, like maybe you agree with minimum wage laws or certain environmental rules.
Right. The ends don't justify the means.
But strictly on adhering to lawful constitutional processes. If you violate the process, you fatally compromise the liberty of the self-governing people themselves.
That's the essence of it. The rule of law itself is paramount.
So what's the fix? If the problem is this profound, what does Smith propose? Is it just about appointing different judges?
No, he's convinced that simply waiting for the political pendulum to swing and hoping for a series of better appointments is totally inadequate. It's unstable. He prescribes actual structural correction.
Structural correction.
Meaning mechanisms powerful enough to genuinely rein in judicial supremacy once and for all. things built into the system itself.
Okay, like what? What are his concrete remedies?
He proposes specific constitutional amendments designed to clarify judicial limits, maybe clarify the definition of citizenship, specifically addressing that subject to the jurisdiction thereof clause in the 14th Amendment, and also amendments to firmly restrict the federal spending power back towards the original, more limited Madisonian framework of enumerated powers.
So amending the Constitution to fix the interpretations he sees as wrong.
Exactly. But he also introduces a more assertive concept, structural accountability for erroneous decisions after they're made. He proposes a mechanism for congressional or even state nullification of Supreme Court rulings that are seen as clear overreaches, perhaps requiring a high bar, like a 3/5 majority in Congress or among the states, to basically restore the issue to its pre-ruling status, forcing the court to reconsider or leaving it to the political process.
That sounds pretty radical compared to how things work now.
It is, compared to the norm of judicial supremacy we live under. And he sees the viable pathway for achieving these kinds of structural changes, these amendments, as the Article V Convention of States movement.
Ah, the Convention of States.
Yes. Smith argues this mechanism, provided in the Constitution itself, allows the states to bypass an unresponsive Congress and judiciary to propose and ratify amendments that reinforce the framers' original design of separated and limited powers.
So, using the Constitution's own tools to fix the Constitution's interpretation.
Precisely. The timeless takeaway, the lesson Smith wants us to internalize here, is that when interpretation morphs into outright legislation, the people inevitably lose their sovereignty.
And the judiciary.
The judiciary, which Hamilton accurately deemed the least dangerous branch at the founding, has, through the sustained practice of judicial supremacy and living constitutionalism, become arguably the most dangerous threat to representative self-rule today.
It's a powerful argument. We really encourage you, the learner, to seek out Smith's book, Supreme Damage, to dive even deeper into the specific cases and the consequences, which, interestingly, he coins as the maleffect of these judicial overreaches on American society.
Maleffect, it's a useful term he develops. And maybe as a final provocative thought for you to consider as you reflect on all this, think about that iconic observation made by Justice Stevens. It was in his dissent in the incredibly hyper-politicized case of Bush v. Gore.
Right, the 2000 election case.
Stevens noted that while the identity of the winner of the election might have seemed uncertain at the time, the clear loser in that case was the nation's confidence in the judge as an impartial guardian of the rule of law.
It's a heavy thought.
It is. So the question for you, based on the material we've explored today from Smith's perspective, is which recent decisions, maybe beyond the big ones we discussed involving abortion or marriage, do you think embody this loss of confidence? When do you see the court losing that trust, seeming to act more based on policy outcomes rather than strict constitutional process?
When do you see the court playing jurist? Essentially legislating its preferences from the bench, instead of truly acting as that impartial guardian of the fixed law. That analysis, that critical look at process versus outcome, is really the measure of the damage Smith is trying to describe. Well, that's about all the time we have. You've been listening to the deep dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shaped liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.
Bye-bye.